Hello, Dr. Bechtel here, and this is a lecture on initiating litigation. For my students, this would technically be the Curley Chapter 5, titled The Complaint. However, there's a lot more than the complaint that gets handled when you write a complaint, and as such, I decided to rename this title in such a way that it makes sense to everyone. First, let's look at the definition of the word pleading. What is a pleading? These are documents that are filed in the court, and they define the nature of the dispute between the parties, the overall dispute. A complaint has a couple of there are a few different things that could be falling into the pleading definition. One is the complaint. And in certain types of actions, such as dissolution of marriage, it's a petition, and a third-party complaint. So those are the types of complaints, which are pleadings. An answer is also considered a pleading, and that includes an answer to a complaint or an answer to a counterclaim or cross-claim, and a third-party complaint answer. Though an answer of any of those types is pleading. And then when there are affirmative defenses included in a defendant's answer, then a reply needs to be made, and that reply to affirmative defenses is also called a pleading. Why do you need to know this? Well, you need to speak the language, and you need to understand, what the difference between a pleading and a motion or notice or discovery or orders. So a pleading is not a motion, it's not a notice, it's not any kind of discovery request or any type of order. And Florida Rules of Civil Procedure, Rule 1.100A, is the rule that you need to consult and know well in order to use the correct language when you're working in a law firm. So what are pleadings for? Well, they're filed with the court, obviously. The plaintiff files the complaint, the defendant files an answer, and these are pleadings. They, as pointed out earlier, discuss the overall standing of the case at hand. If there are related claims against the plaintiff, the defendant can file a counterclaim. Or other defendants, they can file a cross-claim or bring in third-party defendants. If necessary, the plaintiff, co-defendants, or the third parties, they will reply to the defendant's claims. And if necessary, the plaintiff will reply to an affirmative defense raised in the answer or in a third-party answer. Notice pleading is an important topic because the concept is that the complaint needs to simply put a defendant on notice of the claims against him or her. And Florida Rule of Civil Procedure 1.110B covers this topic of notice pleading. It basically says you need to make short and plain statements of the grounds on which the court's jurisdiction depends. 2, a short and plain statement of the ultimate fact showing that the pleader, the person filing the pleading, is entitled to relief. And 3, a demand for judgment for the relief to which the pleader deems the pleader entitled. So remember, the pleader is the person who's filing the complaint or the answer. And the key here is good drafting. Using forms that are available to you will be a good help for you. And checking with the law firm you work at, do they have a specific form? Do they use a document assembly program? And if so, that's a good way to go. It's always right to ask. Let's see, anything else here? And yes, indeed, being a good drafting, which means paying attention, using the right styles and fonts and formats, and all of this, folks, is in your rules of civil procedure, both state and federal. Now, there are exceptions to this, short, plain statement stuff. So in federal court, the federal rules and the state rules also apply here. Rule 9 of the Federal Rules of Civil Procedure state that the fraud, mistake, and special damages have to be specifically pled. So if you look at Rule 9 in the federal rules, you'll see this. The Florida Rules of Civil Procedure 1.120 would not use notice pleading when dealing with capacity of a minor, fraud, mistake, condition of the mind, such as malice or intent. And if you look at that rule, 1.120, you will see that it provides these very points. Just keep in mind that when you think about fraud, it's specifically pled because it's going into a court document, it's going to be public record, and so what specifically happened that constituted the belief that it's fraud needs to be specifically stated. So you're going to use specific facts, not particulars, as you would in notice pleading. Now, a lot actually on the complaint coming up now. So the complaint, as pointed out, is a pleading that states the plaintiff's overall claim against the defendant or defendants. It's the initial pleading that brings the case alive. It states the grounds for jurisdiction. Don't forget we have different types of jurisdiction. We have subject matter jurisdiction. We have personal jurisdiction. We also need to state the grounds for venue. And we're going to use, as in notice pleading, plain, common language. And we number the paragraphs for the allegations. So we'll look at an example here in a minute. So, forms are available, as I already pointed out in a previous slide. Official forms for the Florida Rules, from the Florida Rules of Civil Procedure are a great benefit for you. For example, a couple of forms for complaints that are relatively easy to understand. One is a motor vehicle negligence, and there's a Florida Rule of Civil Procedure Form 1.945 for that. Fall down negligence has a Florida Rule of Civil Procedure Form 1.951. So the overall concepts that you need to plead are in these forms, and you can use the forms, but many law firms will already have a form that they've used consistently. They might also have document assembly software, but know that these forms are also there to help you understand work you're doing if you're new to something or whatever. So there are different elements that are involved in a complaint, and there's a format that's very important. One is the elements of a complaint. We first need to identify the plaintiffs and the defendants, and if accepted from notice pleading, we're going to describe their status and capacity to sue and be sued. So if a minor child has a claim, they can't bring that claim, they would use a guardian or parent, something to file that claim. So that's important to understand. It'll contain these statements that show that the court where this document called the complaint is being filed has proper jurisdiction and venue, and then describing the factual basis for the lawsuit. It doesn't need to expressly state the legal basis. You don't need to discuss legal theories either. Simply, for example, a negligence claim for a motor vehicle accident, that would be the what you would include are the factual bases that describe the duty, the breach, the causation, and the harm, damages, that is. So those 4 points in a negligence complaint are stating not necessarily the legal basis, but the short, plain statements of the facts that apply to that legal theory without discussing the theory. And it also is very important to request or demand some relief from the court, or the case could get dismissed. What else? Okay, format requirements. So there are different sections or pieces and parts of a complaint. We've got the caption, which has this information, the designation. It's also called a title, but the rules refer to it as a designation. So I try to stay with the rules, but also tell you that many people will also call the designation a title. And by the way, the caption in the court rules is called a style. So there are some differences to know, but the language of each term is sometimes spoken differently, depending on the formality of the lawyer or you. For example, when I first moved to Florida, where I'm from, we called it a caption, never called it anything else. But the lawyer I worked for, and I was brand new, said, gave me a project to work, a document to prepare, a court file document. I don't know if it was a complaint or a notice or what it was. It was a court file document. She said, style this in, Weber versus Jones. Meaning what? I didn't know what she meant by styling it. So here I'm giving you some help. Then we have allegations. They come right after the jurisdiction and venue statement. The allegations are in the body of the complaint, and they state the cause of action. And generally speaking, you would use notice pleading in stating the general facts. And then there's always a prayer for relief. This is the wherefore clause. And that's really important. I think I said earlier that a case can be dismissed if you don't ask for relief. And in a complaint, you might want to demand a jury. If that's the case, you need to demand that. And I've got a little more information coming up later on that. And then a certificate of service. But a certificate of service would not be used in a complaint. But the general format requirements for a document being filed with the court is, unless it's a complaint, it would be have a certificate of service. We'll go into that later when we get to motions. Technically, I don't think we'll get into certificate of service in this talk. And then an attorney's signature block, which is going to state who the attorney is that wrote that document and filed it with the court and represents the plaintiff. So the caption or the style is described in Florida Rules of Civil Procedure 1.100C, and every pleading must have a caption contained in the name of all the parties. Every motion, order, judgment, etc. must have a caption. And I will show you an example here in just a minute. And now would be a good time to do that. Hold on. All right, so this is a complaint, and we won't worry too much about all this right now, these little markings and stuff. Just what it looks like this. There's a heading here that shows what court this complaint is being addressed to. We have the parties, Francine Boone, plaintiff, Donald Baker, defendant, and a place for the case number. There will be no case number until after the case gets filed. We name the parties, plaintiff and defendant. And there's this little, what would you call that? It's a line, really, is what it is, but it's a frame. That's what it's called. So this introduces the parties, the court's addresses here, basically. And then there is the title or designation that I just spoke of, and that's a complaint. And we begin with who is filing the complaint, and obviously the plaintiff in this case, and through her attorney sues the defendant with the defendant's name. So initially we set that off. And then the then the jurisdictional points, like action for damages. This says $15,000. This is made in 2008, so this amount for this court is incorrect. It needs to be updated. Residency handles the venue. So in some of the work that you've seen so far, we do ask that you capitalize P in plaintiff and D in defendant. Until I make this new one up, I can't show you right now, but I just wanted to throw that in there. And then we have the general allegations that establish what happened. And so this is an example of simple notice pleading. So on this date, defendant owned a vehicle, and he was at the corner of this location in Sarasota, Florida. At the time and place, the defendant acted negligently, and as a result, the plaintiff suffered bodily injury and has pain and suffering, disability, etc. Loss of wages and other types of relief are available. So this is the prayer for relief. Here's the wherefore clause, which is, this is establishing, number 6 here is establishing the types of damages. So we've indicated, there is a duty. He was driving his car. He had a duty. He breached his duty when he negligently operated it, and the plaintiff incurred damages, which is a necessary requirement. All of those are necessary requirements for a negligence claim. And this is the prayer for relief. Wherefore, plaintiff demands judgment against the defendant for all damages. And the date of the complaint. This is the signature bar. So that's it. And if it were a motion, it would have something else. It would have that certificate of service that we're doing now instead. Working on a complaint. It's that simple. But what goes on behind the scenes, as you learn more, you will see that hold on. You will see that while all that seems relatively simple, yes, indeed. However, it's everything around preparing a complaint that's a pleading of any kind or motion is the particular formats and stuff, formatting using the word processing software. Okay, so describing the parties and identifying who the parties are. In the last example I gave, we gave a example of a motor vehicle accident, and the parties were suing in their individual. The plaintiff is suing in her individual capacity. But again, there has to be every party. The plaintiff has to be a real party in interest, and every defendant as well. So the plaintiff must suffer some loss. And it can be someone with no real interest that they're suing on behalf of another. So this is backing away a little bit from the motor vehicle accident example I just showed. That was for the purpose of showing how the complaint will end up looking. But what's important here is, what I'm trying to describe here in this slide is that someone must suffer some loss, but someone may sue who has no real interest in suing on behalf of another, like the guardian of a minor child, the trustee of a trust, a collection agency that doesn't necessarily own the debt. But those are 3 examples. The status of the party, which means we're going to go back to that point of what their status is, so the type of entity. This applies to corporations, partnerships, and other unincorporated businesses and government agencies. The captioner style would then identify the party as, for example, Paradise Found, Inc., an Idaho corporation defendant. If the plaintiff is a corporation, that too is important to identify. And then you need to, then in that case, you would, whenever you're working with one of these types of parties, like a corporation or a government agency, you're also going to include an allegation, which would be a paragraph in the complaint early on in the beginning, describing the status of the party. So defendant Paradise Found is and was at all times herein mentioned a corporation duly organized and existing under the laws of Idaho. If there are minors and incompetents being involved in the lawsuit, so this case Mary Smith is the person who is the real party in interest. George Smith is her guardian ad litem, and that's the plaintiff. And then here we have the DEF Corporation, a California corporation, and that is the defendant. Identifying, when you're dealing with corporations and other business entities, you want to be clear about their status, identifying their status. This is an example of a partnership, and they're doing business as. So it is important to include both so everyone's clear on, and jurisdiction issues are solved or presented to the court. If it's a governmental agency, then you would use Martin O'Malley, for example, Commissioner of Social Security Administration, the defendant. Fictitious names are important to recognize when you are drafting a complaint. Martin Redshaw, doing business as Marty's Diner, is a defendant, so it's Marty's Diner is a fictitious name. So this is very likely a sole proprietorship that's being sued in this case. A couple of formatting and typing skills are important. The parties' names, use their full name to start and then shorten it. For example, in that first paragraph comes now Janice Jones, plaintiff. You could follow that with hereinafter Jones so that you're not constantly typing out or putting Janice J. Jones. You can just type in all capital letters Jones. But you have to you have to tell the reader of the document that you're going to use that term Jones, and that's how you do it. And if the defendant is Target Corporation, for example, hereinafter Target. Bold in all caps. Okay, my biggest thing that I think is really important is that the party names always be in all capital letters. That would be just the name. You wouldn't put plaintiff in all capital letters, but you would use a capital P and a capital D, as I expressed and I showed you that example. Bolding is something some people do. I never was all that crazy about bolding. I just didn't do it. Anytime you use a type of person's name, you want to include their designation. So Janice Jones, comma, it's important, comma, and as I've already pointed out now twice, capitalized plaintiff, we call that initial caps. So the initial letter of the word is capitalized, P in plaintiff, D in defendant. All right, so we can have multiple parties in a case, and so there could be a joinder going on, but Rule 1.210, the Florida Rules of Civil Procedure, covers joinder of parties, and this is when we have multiple claims. So there could be more than one cause of action. There's count 1, count 2, count 3. So there could be several claims in one case, and there has to be shared facts for this to be done. If you're going to use a multiple count lawsuit, there have to be shared facts. And so one example I like to use is a motor vehicle accident or maybe a slip and fall where the plaintiff is injured. Obviously, that's damages is important. Well, the plaintiff is injured, and let's say the plaintiff is a married person. And then there might be count 2, which count 2 would be, count 1 would be the negligence claim, just like the one we just, if it's a motor vehicle, look like the one we just talked about. And count 2 could be loss of consortium. So let's say Janice Jones is the plaintiff, and Janice Jones was injured in a car accident, and her husband is Alan Jones, and he wasn't injured in the accident, but as a result of the accident and the pain and suffering that Janice is going through, Alan Jones, the husband, is doing more work. I mean, there's more, now the home is his to manage while his wife is in recovery. Now the workload is increased for him. So that's consortium, being able to participate in the everyday aspects of a person's life is important. But when you can't, and there's someone else doing it that you're married to, then you can bring a loss of consortium claim as count 2. So the facts are shared. There's one accident where this has happened, and so the facts are shared. What happened? It's a motor vehicle accident, and both the plaintiff who got injured and the plaintiff's spouse, who is picking up the slack or carrying the water, if you will, while plaintiff is recovering and that sort of thing. And that could be forever, depending on how serious the accident was. So we would have count 1 for negligence. Count 2, in the example I just gave, would be for loss of consortium. And this infographic is just giving you another type of example. And this is done for efficiency in the justice system. We don't have to file 2 lawsuits, 1 lawsuit. It makes things more efficient. It unites all the litigation, and it makes the pleading more clear. So there can be multiple parties, as I mentioned earlier, and there are 2 types of joinder, we call it, permissive joinder and compulsory joinder. So when you have 2 plaintiffs or 2 defendants, let's go with defendants, it could be a reason for this, permissive or compulsory joinder. Permissive joinder would be like where there's a what is meant by permissive is it's voluntary. It's not required in order to bring a lawsuit. So there may be injured passengers in the car of the person. So, multiple plaintiffs in an auto accident is the best way to say that. Construction defects type of case, the contractor and the subcontractor both jointly sued. That's when we would have a permissive joinder. Consumer fraud claims, several buyers are suing the seller. Tenants versus landlord, renters are joining in a habitability lawsuit where 5 people live in a section building of an apartment complex, and none of them are getting air conditioning, and it's hotter than we can tolerate. Or maybe there's other reasons for habitability. Insurance disputes, we might have multiple insurers in the same case. We don't have to list them all. We don't have to name them all as defendants, but it might be necessary. And a business interference, partners suing a third party for interfering with their business. So this is just it's optional. It helps with efficiency and fairness. And again, we have shared issues. Compulsory, meaning these are situations requiring the parties in a lawsuit, all necessary parties in a lawsuit. Property ownership is a big one. Co-owners need to join all property owners in a dispute. In a contract situation, all signatories are needed in contract cases. Partnerships and joint ventures, all partners in this business dispute need to be included. And insured and insurer, both insured and insurer must be joined. And the estate or trust beneficiaries, all beneficiaries and heirs would need to be included. A declaratory judgment is that's where I won't go into that. There are a lot of different reasons for a declaratory judgment. One example I worked on years ago was a man had a trust, and he named I think it was the YMCA. He called it the YMCA, and I'm just making this up because I can't remember where it was, but like the YMCA of South Wisconsin. And nobody really knew what that meant later on. And as a result, we did a declaratory judgment because the son of the deceased trustor had knowledge that it meant the YMCA, that the trust was referring to the YMCA of Wisconsin or whatever. But it was hard for the courts to distribute that money because they wanted to ensure that it was being ordered to be distributed to the right entity. All right, so as I've already pointed out from that example, we need to allege jurisdiction and venue. Recall that we had the example in the first place where the jurisdiction is the residency, why the court has jurisdiction. In that example, it was a $15,000 plus damages. Today, that's $30,000 in the state court of Florida. But we would need to state that as it was done in that past example I showed. If there's something involved in diversity of citizenship, then we would use the United States Code and cite to the diversity of citizenship parameters that bring that to the jurisdiction of the federal court, or if it's a federal question. State laws are different, but jurisdiction generally is where the incident took place. Venue has more to do with the residence, so that the court has personal jurisdiction. So the residence of the defendant, or the location of the cause of action, that would be that corner of whatever where that accident took place, that's venue. And then we also mentioned the residence of the defendant and the plaintiff, which is natural to include the plaintiff's residence. But this is how we get venue, and we tell the court we have venue. So that's really important to understand. What you're doing is telling the story to the court so that they can look at the complaint and know that the court has jurisdiction. All right. So once you're past those 2 points of jurisdiction and venue, you can start listing your claims. Just like that example I had out earlier in front of you, there was a motor vehicle accident. So you may have multiple claims like we talked about, count 1, count 2. That's permissible, and each cause of action has to clearly state the separate counts and identify which party or parties are involved in the relief sought for that count. Multiple parties and causes of action are also permitted in Florida under Rule 1.210 of the Florida Rules of Civil Procedure. We may have multiple plaintiffs or defendants that can be joined when claims arise from the same transaction or occurrence. Prayer for relief. This is really important. You need to ask and demand, and don't forget attorney fees, and be sure to proofread. So ask at the end of the complaint for compensatory damages and costs. And remember that when there's compensatory damages, they might fall into 3 different areas: special damages, general damages, or punitive or exemplary damages. A prayer for relief in a matter in equity, that would be actions in equity or lawsuits which equitable relief is sought, and actions at law are lawsuits in which money damages are sought. Just to keep that clear. Again, types of equitable relief, maybe rescission of the contract, restitution, declaratory relief, I mentioned that already earlier. A quiet title action, that's where real property might be affected by, let's say, a deed that had a typographical error in the legal description, in which case we would need to fix that up so that a title company could still insure the land, and it can be the land can be transferred because technically there's a problem with title, so that's why it's called quiet title action. And injunctive relief also comes into play, like telling a person they should do or not do something. So that is in equity. All of these are types of equitable relief. And then provisional remedies might be a temporary restraining order or a preliminary injunction. A jury demand needs to be included in a complaint if the plaintiff wants a jury. The rule reference is 1.430 of the Florida Rules of Civil Procedure. The timing of it is within 10 days of the last pleading, but typically we request the jury trial in the complaint. Demand, and you can do that with this language, demand the jury using plaintiff demands trial by jury on all issues so triable. That's it. That's all you have to say. Very short, 1 sentence. For jury issues only, so it applies to legal claims. Again, equity claims are tried by a judge. And little typographical error. It was ChatGPT that helped me write these up. So I'm going to be clear that that's not my typo. But you file it in the e-filing portal and you serve it on all parties. So these are important things: preserving a trial by jury, clear demand of what the plaintiff wants for damages, and timely filing three very important points. All right, the subscription I showed you in that example, the signature block, and that comes after the prayer for relief, Elizabeth Jones, Jones and Smith, blah, blah, blah. And in some cases, there's a verification required. Fraud claims, for example, mistake claims, for example, would have in the complaint at the end, usually after the attorney's signature, a verification for the plaintiff. So to sign off that they've read the complaint, facts are stated with knowledge and are true and correct. And then they sign it. When we have exhibits that help to identify the claim, like let's take a foreclosure case, for example, where someone's defaulted on their mortgage payments. So we would attach the mortgage and the promissory note as exhibits, and we would refer to them in the body of the complaint that we have are attached here to and incorporated herein is the promissory note dated blank date and signed by the defendant, and it's incorporated herein as Exhibit A, and so that would be the note, and the mortgage, same type of language, incorporated herein as Exhibit B, and then you attach those. So here's a nice little checklist. Review all local rules, very important, because there can be special formatting requirements, or there just are. It's not just in the local rules, it's in the state rules. Make sure you've included the title of the court, identify and name the parties when you type the caption /style. Call it they call it designation, but the title of the document needs to be included. Don't forget the demand for a jury. Each cause of action would need to contain a statement of jurisdiction, identification of the status and capacity, and a basis for the claim, and description of the damages. You have to state at least one cause of action against each defendant, and you're going to include a prayer for relief, as I mentioned, and signatures, verification, declarations, etc., with exhibits attached. So a little checklist for you. Class actions. So class actions are governed by the Florida Rules of Civil Procedure. I'm sorry, strike that. The requirements for class action lawsuits in Florida. First of all, the rule is 1.220, which governs class actions. There has to be a common question. Has to predominate over all the individual issues. And the questions of law and fact have to be common to the class, the group of people. The representative, typical claims, it has to be representatives' claims and defenses must be typical of the entire class. And adequacy and numerosity, adequate representation, and class is numerous. Jurisdiction can be federal versus state. Federal court, we use diversity jurisdiction, or the class actions act when they're over 5 million, and if they're multi-state classes, we need to go to the federal court. And then state court, there's no amount requirement. All Florida parties would be included, and be a Florida-based class, so it would not be the whole nation. So federal court can be an important choice if you want to take it further than just Florida. The court needs to certify the class, and that happens as a separate process, and define the class and its representatives. So remember, common issues, typical claims, and use the proper jurisdiction. All right, so that's everything on the complaint. Now we need to look at the other areas that get covered in initiating a lawsuit. For example, the summons and how you serve process, which is serving the complaint and summons on the defendant or defendants, civil cover sheet, and notice of confidentiality. These are Florida requirements. So the summons is what's going to tell the defendant and give them notice, also known as due process, of the lawsuit and the deadlines they have to follow. There's a form for a summons, Florida Rule of Civil Procedure Form 1.902. It does have three, four maybe languages that that the summons is written in, so that a defendant of the most prominent languages in Florida is able to read it in their native language. I think it's Spanish, Creole. They might have added French. I don't remember, but you can look at the statute and know. So the workflow, what you're going to be experiencing as a paralegal when you draft a complaint and a summons, you're going to handle the summons after the complaint is filed, or at the same time. So the clerk will issue the summons, so after you file the complaint. So it's filed by the plaintiff, and the clerk of court has it. The case is opened by the clerk of court, and then the clerk prepares and issues the summons. The summons is given to, summons is returned, in other words, it's given to plaintiff's attorney, technically, if you're working in a law office. The plaintiff then has the responsibility of arranging for service of process. Many times you can hire a process server, you can use the sheriff, or a certified process server. Summons and complaint are both served together, and service of process, the process server serves the defendant according to the rules of service. And a return of service then is done by that process server, sheriff, and the defendant has 20 days to respond in Florida. Who can serve a process in Florida? A sheriff, or a special process server, or a certified process server. These are all governed by Florida statutes. And some little notes here, like the sheriff, that's like a default officer for service in the county where the defendant is found. Appointed by the special process servers, appointed by the sheriff. They have to meet training and background requirements. Certified process servers go through the chief judge of the circuit court in the county or in the district, and they can serve statewide if they're authorized. What you'll find in law firms is that do litigation is they already probably have a certified process server that they contract with to do all this work, someone they trust, someone they pay to do the work, but it's a relationship, an important business relationship. So that's the summons. There's also the need for a civil cover sheet. This is simple. It's a form. It's nothing more than a form. It's filed once at the beginning of the case. It allows the clerk to properly assign the case to the right division of the court, family, circuit civil, traffic, whatever. And also provides data to the court system. And that form is at Florida Rule of Civil Procedure Form 1.997. Notice of confidentiality is another document that gets filed with the complaint. This is governed by the Florida General Practice and Judicial Administration Rule 2.420. If there's personal information in documents, it's important to do this document so that it can be access can be restricted, because generally speaking, court files are available to the public record. So you need to use care and look for confidential information. I'm going to go into that in more detail in the next slides. So it's Rule 2.420 that governs this. We have personally identifiable information, PI, and things like social security numbers, financial account numbers, protected personal addresses, private contact information. All this is confidential information. Sensitive records are also medical and mental health records, HIV test results, juvenile records, guardian ad litem reports. Keep in mind, this is what the rule says, is as a rule, these things are all considered confidential. People are sometimes you have to be very careful to avoid giving information that would possibly lead into domestic violence, like a domestic violence shelter that a person is staying at. You don't want to disclose that. You don't want, and if you do disclose it, you need to be careful to use the confidential information. And criminal intelligence data. Family court matters kind of falls into some of these, by the way, too, but family and court matters, their adoption records, judicial deliberations, education records, those are considered confidential. So what you can do as a paralegal is, one, identify the confidential items. You write the complaint, be careful to watch those so that you know to file a notice of confidential information. The clerk will then be able to restrict or redact the information, and the motion to determine confidentiality can be used if it's needed when there are situations that aren't on this particular list. I think the rule, I think there's 16 or 19 different areas, so that looks like 3 times 4, there's 12, oh no, there's 8, 14 here, but I think they're like 16 or 19. So your workflow, paralegal needs to check the document they're drafting. And, you know, if you think about dissolution of marriage, there's a very lot of confidential information. That just goes in there automatically. But prepare a notice of confidentiality, list the confidential items, and give a page and paragraph, cite the legal authority, the rule, if it is, in fact, one of those on that list earlier that's in the Rule 2.240, you'll need to, in the Notice of Confidential Information, explain what's confidential. File the document. You file the Notice of Confidential Information with the complaint, and use the Florida e-filing portal to do it. And the clerk will review it and restrict the access, as already pointed out. If a notice isn't filed, the clerk will hold it for 10 days and notify the filer to correct. So they're going to look at it, but if you didn't file a notice, the clerk is going to get in touch with you. And now there's also an opportunity, if needed, to file a motion to determine confidentiality for any of those items, any items that are not on that list of Rule 2.240. And the court will review those and seal them, and that's all done by order because you filed a motion for it. So our checklist for filing a lawsuit is: you do a complaint, you do a summons, you do a civil cover sheet, notice of confidentiality, you pay the filing fees, and you do that in Florida through the e-portal or through the CM/ECF in the federal system. A little bit more on that, public electronic filing and electronic information. For example, federal courts have the PACER, Public Access to Court Electronic Records, and the here we have case management, electronic case files. That's where you file stuff, but you also get the attorneys have access to the case file through case management, electronic case files, CM/ECF, in the federal courts, and they can also go use PACER. PACER, I'm not sure anymore how accessible it is to the public. It used to be. I haven't checked for a long time. But a notice of confidentiality, think about it, bankruptcy has a lot of information in it. That's a federal court case. All right, so state courts, they have their own rules and procedures for e-filing, and Florida's obviously are the ones I'm concerned with. So these are the steps. You're going to prepare the complaint, you're going to go to the portal, you're going to file the new case, you're going to upload documents in PDF, you're going to pay the filing fees, and the clerk is going to then review everything that you filed. And if everything looks fine, and you have all the documentation required, the case number will be issued, and then you retrieve the summons from the e-filing portal that has been basically electronically prepared based on the information that you've entered into the system. All right, let's see. So service of process. This is a topic that actually is, it's a big job of paralegal to make sure they're doing the service of process right. And I know that lawyers do count on you to do that. It says here, Chapter 46, I think it's Chapter 48 of the Florida Statutes, Rule 1.070, the Florida Rules of Civil Procedure. As I pointed out earlier, only certain people can are able to serve, and we might use the sheriff or a certified process server, and basically that's after the clerk issues the summons. Different methods of service, you can go individual. The statute, it is 48, it's definitely 48. For individual, you would look at statute 48.031. Corporation, we're going to look into these in more detail, but these are the specific statutes for the different types of service. You'll get proof of service from the process server, as I pointed out earlier, and that gets filed with the court. There's also opportunities for constructive service by publication, and as we're going to learn, there's also service of process through the Secretary of State for elusive witnesses, elusive defendants. But the key principles are service is how you get jurisdiction. So service needs to be done correctly. It's very important. It can get the case dismissed if you don't. It deals with due process. It's so important. And so you get proper service, you get the proof of service, or sometimes there's a need for court authority to help you do that. Service of process under the federal rule, that's Rule 4. The summons gets issued, the court name and the parties are in there, and what that means is, just like any summons, the summons is going to tell the defendant what court this is filed in, the address of the court, who is suing that person, and the complaints attached to it. So they get good amount of notice there. It has to be served within 90 days of filing the complaint. And then there are different methods of service in the Florida, in federal. Personal, the same is true in the state court, the state system too. Personal delivery, service at home, an agent or officer of a corporation, or serving at the United States and corporations will have their own special service. People can waive service both in the federal and the state system. We'll go into that a little bit more in a minute. The proof of service, and you file, just like with the state, you're going to file proof of service. You use an affidavit from the process server, or also called a return of service, or you place a waiver of service in the file that the defendant has signed. If it's not served within 90 days, just like state, you risk having the case dismissed. So waiver of service is pretty simple. They can waive it. You can send a request with a copy of the complaint, send them a form, waiver of service, allow them 30 days or 60 days if they're sending it to them internationally. Defendant can waive service or not and refuse and end up paying some service costs. File the waiver with the court then, and then the defendant gets 60 days to answer if they have filed a waiver of service. And that can be helpful to the defendant to sign off on that because they get more time to deal with things, find their attorney. 20 days is a short period of time. Wow. And that's a required amount of time under standard circumstances. You can also do service of process online. So there are some more modern methods for serving legal documents. See, this is Florida. Florida Court's e-filing portal. You can the summons is issued, and you can go this route or use electronic delivery served by an email, portal upload, or e-notice. You need to have the identity of the person securely verified, and the proof of service is filed. And the response period, then they have 20 days. So it ensures due process, secures a transmission, the document. That has to be a secure transmission and electronic record keeping, and Chapter 48 is where you go for more details on this. Corporations in Florida in Chapter 48, 061, Florida statutes allow corporations can be served with legal documents through their registered agent. And you get that information from the Secretary of State's office. An employee of the agent serve an employee if the agent is unavailable. The corporate officer can also can be served in lieu of the registered agent. And if there is no agent, you'll serve it through the Secretary of State. And then you can file a return service form. Registered agent is the preferred method to go when serving a corporation, but there's alternate options included here in the statute. Secretary of State is a backup. Also, sometimes a complaint needs to be amended, and when that's the case, it's Rule 1.190A of the Florida Rules of Civil Procedure. So the steps to amend a civil complaint in Florida courts include the initial complaint is filed, a responsive pleading is filed, like an answer, and then you might make a motion for leave to amend. And that means you get the court's permission. Judge grants leave to amend, and the amended complaint is filed. We do this sometimes to correct errors, add a claim. You'll file using the e-filing portal when you have your amended complaint ready, and you serve it on all parties, and it's all just a matter of justice and fairness. Amendment of the complaint says. All right, so that's it. That went faster than I thought it would. It is almost an hour long, and I apologize. It's a lot of information in this one, a lot to talk about. So thank you very much.